How it's going to work is I'll start off by doing a presentation on winding up petitions, in particular ways in which we can try and avoid unwanted adjournments. And then I'll hand over to Lauren after, and she's going to look at applications for an extension of time to register charges with Companies House, which is quite a word.
Catchy title.
Yeah, exactly. So let's begin. So this is about creditors winding up petitions. So I'm going to go through the common pitfalls that we find that lead to adjournments, and then identify a number of practical steps that can be taken to try and avoid those adjournments. So the common pitfalls tend to be of four. There is 1, missing documents; 2, errors in the document; 3, that no notice of the petition has been given; and 4, the documents just aren't filed in time. So I'm going to attempt at the moment just to put up a poll, which should have launched. And the idea is that if you could indicate whether you've experienced an adjournment for any of those reasons, and if you experience more than one, just select the most common one, just so we can get an idea of what's the most common pitfall.
I haven't tried to predict what the conclusion of this is going to be, so I'll be interested to see which one comes out on top.
It's quite interesting. I'll give it about another few seconds, just to see if anyone else wants to come in. At the moment, it's looking like errors in documents seems to be taking over.
Yeah.
I think maybe I can just leave that to go on, and I can go to the next slide, and then I'll.
Yeah, I think you can move it to one side.
Great. So these are the 4 elements we're focusing on. We're going to look at the statutory framework behind those elements, where you can find the rules. So generally the Insolvency Act 1986, the Insolvency England and Wales Rules 2016, and the Insolvency Proceedings Practice Direction. Just at the outset, although I'm focusing predominantly on those 4 pitfalls, I would just emphasise that there are other steps that obviously need to be taken. So before you even present a petition, you need to look at whether there's one already pending against that company. If you present one where there's already a petition pending against that company, you're taking a risk as to costs.
Emma, we've got a raised hand from Beth Balcom. Beth, I'll just click on allow. Oh no, has that gone? I think that's gone.
Okay.
Okay. Sorry, Emma, carry on.
If you conduct a search and there is a petition already pending, your options are you could contact that petitioner and determine the status of the petition. Then you could give notice in support or opposition of the petition, and if that original petitioner actually gets paid or seeks dismissal at the hearing, you can then seek substitution. So just because there's already a petition pending, it doesn't end the actions that you can take. Oh, right, okay, the poll is now closed. I'll just let you know that the most common pitfall is actually errors in documents, followed by missing documents, and then documents not being filed in time. So thanks for that. That's very interesting. So moving on. So the first step is to file all of the required documents. I set out a list of those. So the petition, obviously, then you need to verify the petition. You also need to file both a certificate of service, a certificate of compliance, a copy of the notice of the Gazette, and generally that's kind of included within the certificate of the compliance, and also the list of appearances. I've included a link, and that should take you to the government website, which includes sort of a sample of those documents, which is quite helpful.
And we will, I think Steph will send these around to everyone, these slides. You would usually, for those who've been to our junior programmes before, have a pack with these in, but I think Steph will send them round, and we've hyperlinked the links into the presentations, so you'll have those for later, I think.
Excellent. And yes, I'd add, with these documents that are required, you'll see that statutory demands aren't included because they're not essential, but it is something to consider in advance of a petition, because obviously a company that fails to pay a statutory demand for a sum exceeding 750 is deemed unable to pay its debts. So even though it's not an essential document for the petition, certainly something that you might want to consider. So moving on to the second pitfall, which was the errors in documents, and highlighted as the most common pitfall. So the best way to get around this, I think, is really just to check that everything that's listed in the insolvency rules is included, and also just check that all of the details are accurate, and go onto Companies House and just cross-refer each of the details. The rules are very prescriptive, and the forms that I've indicated on the previous slide do prompt what you need to include. But I'm going to set out essentially the rules that set out what you need. So for the petition, these are set out in Rule 7.5, and as you can see, it's really quite detailed. I'm not going to go through all of them, but I'll just highlight a few that tend to see some errors, which are the identification details for the company. So mistakes in the spelling of the company's name, or mistakes in the number. Also issues with the date of the incorporation and the enactment, so listing the wrong Companies Act, for example. And then also sometimes issues with the shares. I'm going to come back to J, the grounds on which the winding up order is sought, because there's further guidance as to what to include in that. Rule 7.5 continues with further requirements. I'm not going to dwell on these for too long. Lauren, I don't know if you want to say anything about Article 1.2.
Yeah, I would just say that be very careful when you're using the standard form, because it's helpful in that it sort of gives you all the options, it offers you bits to cross out, but often people will leave the wrong thing in just by accident usually, and the most common one in my experience is M there, and it's whether it's an Article 1.2 undertaking, and you have to confirm that it isn't, but people often say that it is, so it's an insurance undertaking, or there is a list, and sometimes that is a reason, or I've certainly known that on multiple occasions to be a reason that the petition then has to be amended. And that's such a small thing. You've crossed through the word not, or haven't crossed through the word not in the wrong way, but it can cause annoying and unnecessary delays. So that's one in particular to flag. And
the definitions, obviously, of Article 1.2 undertaking of main proceedings, they're all given in Rule 1.2 of the insolvency rules. I haven't listed here, but the petition also has to include a blank box for the court to complete with the details of the venue. So going back to what details you need to include about the actual debt, this is in the practice direction. So generally you need to say the amount of the debt, its nature, the dates on or between which it was incurred. You just need to give like all relevant details, and even if you've put it in the statutory demand, the practice direction says still include that in the petition. And also, just as a point on the debt itself, it's just a reminder that this process is obviously for undisputed debts. So you shouldn't be presenting a petition if there's any dispute, really, and it shouldn't be used as a method of enforcing debt collection. If the debt is disputed, you're not going to get a winding up order. You might get directions for a disputed debt hearing, for example, at the hearing. Just one more point on the contents of the documents. The practice direction does also include a sort of saving provision in 9.4. So if, for example, you can't, because of the nature of the company or the place of incorporation, you can't give the information, then you give as much similar information as you can. So moving on to verification. So what you want to do, this is essentially a statement of truth, and it can be done on a petition, but generally it's done in a witness statement alongside, and this is because there are certain things you need to include within that witness statement. So I'm just going to go to the next page, which is to do with the centre of main interest really of the company. So this is whether it's main proceedings, and so that is to go in a witness statement. Right, I don't think there's much more to add. Oh, sorry, to add with verification. Lauren, do you have anything else to add on?
Nope. Oh, except for, sorry, anecdotally, I have had this before, that this confusion about whether it's done on the petition or separately. Bear in mind also that you listen to what Emma said. Bear in mind also that the statement of truth has changed recently from the start of the month. So if you don't do a huge amount of litigation, we haven't come across that. The statement of truth doesn't now just say, I believe that the facts in this document or whatever stated in this document are true. It also then has an additional warning about basically, if you lie in this document, you might go to prison for contempt of court. It's just to firm up the emphasis on telling the truth in legal documents. So that's just something to mention.
Right. So moving now to the certificate of service. So generally you're serving on the company, possibly might need to serve on other persons, and this is set out in Rule 7.9. Service on the company is in accordance with Schedule 4, Paragraph 2, and usually it's best to get a process server to do this, and they need to, service is basically going to the company's registered office and actually handing the petition to director, employee or officer of the company, and if you can't, in the absence of one of those persons, then it can be deposited at the office in such a way that it's going to come to the notice of the person attending the office. The service of the winding up petition must be verified by a certificate of service, and this needs to set out those elements that I've included. I'll just draw attention to the manner of service and the date of service. So it needs to say what actually happens. For example, the process server handed it to X, who at the time acknowledged that they were a director of the company. The winding up petition is treated as a claim form. So the deemed date of service is in line with claim forms, which is the second business day after that action. So that's just something to bear in mind when I come on to discuss the relevant time limits. Then we've got the certificate of compliance, which basically sets out that you've advertised and you've given notice. You've given notice in the Gazette and you've served the petition, and with that you would generally include the notice of the petition. And I'm going to come on to the advertisement requirements shortly, but I don't think we need to sort of go into this in much detail. Finally, the last document is the list of appearances. So you've advertised the petition in the Gazette, and by 4 p.m. the day before the hearing, you might receive notice from creditors in support and opposition of the petition, and you then need to create a list of all of those and present that to the court. So that's really the contents of the document.
And I would just flag as well on that, you should have a nil appearances list, so you should just have it's just the template but with no one in it, if no one has appeared, just for belt and braces, to make clear and to confirm that you haven't received any notification of anyone who intends to appear on the petition.
So third tip, advertise the petition in the Gazette. This is really important because the winding up remedy is a class remedy, so the petitioner has to alert other creditors so they can give notice of their support opposition. And the relevant rules are set out in 7.10. Again, I've just set that out, but we will move on, because one of the main problems is that it's not advertised by the first hearing in the Gazette, and so the court then adjourns that. And usually this is because the parties might want to settle. So the court grants an adjournment for settlement or for advertisement. And then it comes back at the second hearing and it still hasn't settled, but the petitioner still hasn't advertised the petition. and this is problematic, and it's likely that that petition is going to be dismissed. And this is set out in the practice direction, which says that no further adjournment will normally be given.
The other thing to flag about that is often this happens, and people, you're not supposed to use the winding up procedure to put pressure on a company on a debtor to pay. People very regularly do, and often it works. And you'll present a petition, you don't advertise it, you have your first hearing. Between the first and the second hearing, often the company will pay up. But the problem then arises if you can't agree on costs, because you will say to the judge at the second hearing, when you still haven't advertised because they've paid the bulk of what you want them to pay, well, I'd just like an order that the petition be dismissed, but we have our costs. And very often the judge will say, well, you haven't advertised, so you're not entitled to your costs. So it's a bit of a Pyrrhic victory sometimes, in that, okay, you've been paid, but you've also wasted quite a lot of money trying to get that money back with no recourse on costs. So that's another potential issue to flag.
Just as an additional issue, this isn't really in relation to adjournments, but if actually you've done everything fine, you've advertised it the first time, but now you're seeking dismissal of the petition, it's just to draw your attention to paragraph 9.8.3 of the practice direction, which the rules reiterate that you have to give notice of that dismissal, and the practice direction gives the examples of where the court will usually on request just dispense with that. So I've set out the three situations there. In relation to C, what I have seen is to evidence the company's consent, the petitioner has a letter that's then signed by the company, an officer of the company that gives their consent to dismissal. And that means that if the company is not present at the hearing, the petitioner has something to show to the court that they've consented. So the next pitfall, which was in relation to time limits. So to address this, what we've done is we've created a table essentially of indicating some of the relevant time limits of when the actions should really be taken. So looking at the first, presenting the petition, the only time limit I would really draw attention to is if you are doing it after serving a statutory demand, just remember that there has to be that 3-week period. Verifying the petition, this is set out in the practice direction, which says that it has to be done quite close to the date of issue. We've already discussed service of the petition, so the deemed service date will be the same as a claim form, so it's the second business day. Then giving notice in the Gazette, neither too soon, neither too late. It really depends on when you've served on the company and when your hearing is, and trying to sort of go by the date in the middle, really. The practice direction for filing evidence of gazetting says that you should lodge a copy with the court as soon as possible after publication, and in any event not later than 5 business days before the hearing. Generally, I think it's attached to the certificate of compliance, because the certificate of compliance requires a copy, and that is at least 5 business days before the hearing. And then the list of appearances is generally handed up to the court on the day, although that's not, in practice, that doesn't really happen in the High Court in London. It's usually best to just file a copy with the court. The time that I've actually seen the list being handed up to the court was in Manchester rather than in London. So the other point I would just make on time limits is that the rules on the timings in the rules refers to the CPR and the clear days. So just remember, if you've got to do something 7 business days, that's 7 clear days between the 2 events. Final sort of tip is that it'll be okay if there's a formal defect because of the saving provision, and hopefully that will provide you with some with an opportunity to get around getting an adjournment. So this will help you if there are very minor defects. But in any event, if if you do have to get an adjournment, it's not the end of the world. The point is just to remember that if, for example, you're being asked to amend the petition, just be clear whether you also need to re-verify, re-serve, re-advertise, because you don't want to get to the next hearing and you've amended the petition and then the court has asked for where that re-verification is, and then you get another adjournment.
I think in a way, because the stakes are fairly low in that your adjournment is 7 days, for instance, that's the shortest adjournment you can get. And the judge thinks, well, I'll just adjourn, get them to do it right. And so in that sense, they're sort of less inclined to help you out than you might get other judges do, where they know that if they adjourn something, then it's going to be 3 or 6 months down the line before you get another listing. But that can have a cumulative effect in that, you know, you adjourn it once for 14 days and then very quickly it only takes another couple of adjournments like that and you're a couple of months down the line. So worth getting right the first time, but yes, it's not the end of the world if you don't.
And finally, well, hopefully we've covered off how to address most of those common pitfalls, and just a brief mention as to sort of what's happening now with winding up petitions. They're still taking place weekly and remotely, generally by Skype for Business, and that has contrasted quite a bit with insolvency work before Insolvency and Company court judges. The lists are usually split between HMOC and non-HMOC petitions. Lauren, I think you had one this week. I don't know if you want to just...
Yeah, I did one a couple of weeks ago. It actually all went very smoothly. It was much more straightforward than the normal list, where I don't know how many of you have been to the winding up courts, but for those who haven't, you go into a big courtroom in the Rolls building. Everyone's robed for strange and old-fashioned reasons. You are in there with another 200 other barristers and directors and solicitors and other people. And you then wait for 2.5, 3 hours. I mean, it's been getting longer and longer lately. And then you just wait for your matter to be called. This way, because the lists are a bit shorter and because they're more split up between different time frames, you're given a Skype link. You call in at the relevant time. You might have to wait 5 or 10 minutes. That was my experience. But then the judge comes in and they just do the list in order. So I found it to work quite well. I think as a general proposition, I would say HMRC are being a bit less stingy with adjournments than they usually are, as are the courts. I think they're happy to just get through the list reasonably quickly and get it dealt with for that week. So it's not a terrible time to have a winding up petition presented against you in that way. I don't know how the knock-on effect is going to play out with this, because for a couple of weeks the courts didn't do this list. And they were all adjourned off to the summer. The summer is fast approaching, and it doesn't look like the courts are going to be able to be back to normal by then. So it may be that it will start to get a bit more cumbersome and a bit more difficult the longer this goes on, because these petitions can't wait forever. But for now, it's sort of ticking over. It is still happening. You still need to do everything by the time limits that Emma's set out. And yeah, we titled this "Avoiding Unwanted Adjournments" for a reason with regard to winding up petitions. Sometimes, very often, an adjournment is exactly what you want. So now is not a bad time to get one if you want one.
And just talking about what might happen, I guess, when normality resumes. If there is a backlog of petitions, because great numbers of these have been adjourned, then it's quite possible that lists are going to look very full. So all the more reason to try and get everything as right as you can at the outset, because if you are then getting adjourned, you don't know how long it's going to be until there's an open space for you to come back on. And if it's just to do something as amending a small minor matter in the petition, you don't want to be going on for a long time before you can get back to the court. The other update that I just wanted to draw attention to was the announcement of the government in April, on the 23rd of April, about commercial tenants, really, at high street shops and companies. And it's all kind of focusing on this idea that they're going to be protected from aggressive rent collection. So statutory demands and winding up petitions are to be temporarily voided between certain dates. And in relation to winding up petitions, those dates are, I think, the 27th of April until the 30th of June. So there's a temporary ban on petitions where the company is unable to pay its debts because of COVID-19. Now, it's not clear how this is going to play out in practice, but the notes to that announcement about any winding up petition that claims a company is unable to pay its debts must first be reviewed by the court to determine why. So there's almost implementing a preliminary step, and they're not going to permit petitions or orders where it looks like the inability to pay is because of COVID-19.
Okay. Brilliant. Okay, so as the snappy title suggests, extension of time to register a company charge. These are, I don't know how many of you have come across these hearings before, but they are heard in central London, so some of you may have come across them in that way, and they are, I'll explain the statutory framework and the reason that you would need to make these applications. They are quite unique to themselves and come within their own statutory framework, but they are absolutely notorious for very long, very annoying adjournments being ordered by the courts. So definitely, if you're trying to avoid adjournments that you don't want, this is useful, I think. So I'll go through how you prepare the claim in these matters, how you prepare for the hearing, and then the crucial bit, the pitfalls and how to avoid them. So preparing the claim, I'll just go through the statutory framework. It's the equally snappily named sections 859A to Q of the Companies Act 2006. I'll set out some of the background. So as the title of the presentation suggests, the section applies where a company creates a charge. I've put company in bold there, that's important to flag. A section, everything in this is horribly lengthily named. A section 859D statement of particulars must be delivered to the registrar within 21 days, beginning with the day after the date of creation of the charge. So 21 days is the, 21 days is the crucial deadline there. There are some exceptions in 859A subsection 6. Those are not very likely to arise, but I just flagged that they're there. Section 859D, this is the one which has the details of the statement of particulars. So things like the registered name and number of the company, all of those sort of common things that you would expect to need to provide to the registrar of companies, just the general details of the charge that's been created. And then section 859F, this is the one that you're going to care about. There is a distinction between this and section 859M. I'll come back to that. Section 859F is the provision which recognises that mistakes happen, recognises perhaps that 21 days is not a very long time, and that's 21 days full stop, it's not 21 working days. And so section 859F is a provision which catches those errors and gives you a way out of that in order to still be able to register your company charge. So the circumstances in which you can get an extension of time are, firstly, you haven't delivered the documents that are required. So either you've not done it at all or you've done it too late. And also you've met this requirement, which is that the failure to deliver those documents was accidental, due to inadvertence, is not of a nature to prejudice the position of creditors or shareholders. Now, look at those words, accidental, inadvertence. I've never seen one of these where it's been for any other reason than someone went on holiday and therefore the matter fell through fell out of people's minds, or somebody didn't hand over this particular matter, or someone left the firm and it didn't happen. It's always those kinds of things. They didn't put it in their diary and forgot. It doesn't have to be a good reason. It just has to be a genuine reason. And that's something to flag, and I'll come back to this in what you need to prepare, but just to flag at this stage that the section identifies that it's matters that are accidents or are inadvertent. And then there's your crucial one, which helps you out. The court can allow you to extend, and in practice it will order that you have 21 days if it grants you your order. This is the effect of the messing up, the mistake, and it's essentially the charge is void against those three classes of persons. So a liquidator of the company, an administrator of the company, a creditor of the company. So these are the times when you're going to care about your charge being secured, because if the company goes into liquidation, you want to be first in line to get your money. That's why you've bothered to execute a charge in the first place. And if you haven't done that, if you haven't complied with the provisions of these sections and subsections, what will happen is it's not that the person doesn't owe you the money, or the company, I should say, doesn't owe you the money that you've lent them, but rather that you become an unsecured creditor. And obviously, in practice, as many of you will be aware, that will mean you will go into the pot with everyone else. You'll get your 1p in the pound. And in practice, for conveyancers and solicitors dealing with these registrations, potentially, if there had been assets to pay out against the secured lending, you need to notify your insurer that there's going to be a claim coming, because the lender is not going to be very happy that their security is effectively unsecured. Section 859M is another one to flag. You will sometimes need to make an application under this subsection. It's where the notice has been delivered, so you've sent your notice, your section 859D particulars off, but you've made a mistake in that. So there's an omission or a misstatement, something in that list of things you need to include either you haven't put in or it was wrong. And again, you make a similar application referring instead to section 859M, and the court essentially will order that you have an extension of time in exactly the same circumstances where the mistake was accidental or due to inadvertence. So what do you need to prepare a claim? It is a claim. They have to be issued in central London, county court. People do still issue them in the High Court, and they will transfer them, but it's likely to cause delays, and it's worth doing it in the right way from the start. So have a look at those guidance notes if you've got a copy of the White Book. You issue it by way of Part 8 claim form. Expressly, the guidance is contained somewhere. I suspect it's in the White Book guidance. You don't need to join any other party if the company is the claimant. So that's the usual way that it's dealt with. Appendix A or B, it will be Appendix A if it's a Section 859F claim, or Appendix B if it's an omission, misstatement, Section 859M claim. But it is not the one on the HMCTS website, unless your charge is dated before the 6th of April 2013, in which case you are pretty late in delivering the particulars of that charge. So not the one on the court's website. I don't know what to tell you. It's been on there for years, clearly. They've never updated it, or they've never provided you with an alternative. They've never flagged that it's wrong. And so many people use it because it's quite an unusual form. You don't have an Appendix A for other sorts of claims. So people just use the precedent that's available to them, and then they end up getting the matter adjourned. So I'll come back to the one you should be using, but don't use that one. A supporting witness statement, as I say, be honest about why the delay has happened. If you just, as I say, there can be no reason at all. If you just didn't put it in the diary, didn't diarise it and forgot the deadline, just say that and say that you're terribly sorry. It was completely inadvertent. I don't know what circumstances the court's envisaging for someone having done it on purpose, some sort of malicious failure on the part of a conveyancer or a solicitor to file the statement of particulars. But yeah, be honest about that.
Lauren, just on that point, I just add, I think it's really important, the explanation. So don't just copy the provision of the statute which says, you know, it was due to inadvertence or accident or other sufficient cause. You have to set out what that was.
Absolutely, yeah, thank you.
What went wrong?
Yeah, definitely. Yeah, just be as thorough as you can be. If there's a really long and convoluted reason that it happened, then put that down. It's only going to take you an hour to put this statement together, and it's worth being thorough, because it's completely at the whim of the courts, and we'll come back to this, but you may well get a district judge who says, well, I'd really like to understand who exactly was on holiday and how long were they away for. Just put all the detail in, and then at least you've got it all there. And then the other thing you need to do in preparing the claim is to exhibit a copy of the charge. The bit in brackets, I've put in brackets, but actually probably shouldn't, because it comes up more often than you would think. The most recent set of these I did, which was actually the last hearing that I did. It was the 23rd of March, and lockdown was announced that evening. So it was the last in-person hearing that I had, and it was in this list. And there were multiple attendees in that list who just didn't have a written charge. And in the end, they got dismissed because they were curious. But there are odd circumstances. It's not always as straightforward as having a properly coherent and cohesive set of documents. So if the charge has been lost, which does happen, you need to explain what's happened. You need to explain what steps you've taken to try to find it. You need to explain what the director's done, and so on and so forth. So again, it's just a question of being as thorough as possible. But that, I should flag, is a copy of the charge, and I'll come back to why that's important. I've set out here some templates, which, just in case you're ever preparing one of these and you think, yes, I've got that presentation I'll go through, this will take you through to links to the relevant documents. And yes, again, the guidance notes, which are in this document, the supporting witness statement document, that again has out-of-date references, and that's the old section of the Companies Act, the pre-April 2013 section, so don't refer to that. Also, just a thing to flag is that you should include confirmation in your witness statement that an extension of time will not prejudice the position of the creditors or the shareholders. Call counsel, call somebody if you think it might, and you can always talk through what your options are. But in the normal course of things, nothing will have changed in the interim, and it's just worth, or you need to include confirmation that the extension is not going to prejudice the creditors or the shareholders. So you've done all of that, you've got all your documents in, you're feeling good, you've done it all properly, it's very thorough, you've got a 300-page witness statement, you've got every possible piece of information about every holiday you've ever taken in there. You might think you're done. Wrong. Further documentation required. This is like a riddle, this bit. Now, what you need to include is not a riddle. It's just a very standard form. You need to say that the company is solvent. There's no winding up order. There's no winding up petition. The company's carrying on business, all those things. But the problem is it has to be original evidence of solvency. Now, what that means is not a copy that the director has scanned and sent to you having signed it, or any officer of the company. The original that they have signed with a pen, and the judges run their fingers over the documents to check that they're actually signed in original form. This reminds me of being at school and copying, my sister scanning in a piece of work that I had written out 2 years prior, and her teacher catching her by running her finger over and saying, you didn't write this. It's a similar thing. That's what they do. So it has to be the original document that the director has signed. But the difficult thing is it has to be dated within the 14 days before the hearing. So what you need to do is draft up your evidence of solvency, this very brief document, with the statement of truth. Director send it to the director then prints it off, signs it by hand, and can't then just scan it in and send it back to you. They have to then post it back to you, and you then have to post it or they can post it directly to the court themselves, but in practice it's probably going to be you. You then have to post it to the court. So it has to be all done within that 2-week period, and in practice the rules provide that you have to have it to the court 2 days at least before the hearing. That's a practical reason that the central court, the county court at central London, is not going to get it onto the file if you don't have it there 2 days before. And in practice, you should try to get it there as many days before as is physically possible, to give them the best chance of getting it onto the court file. So that's something that that you need to make sure you do, and they will not give you your order if they don't have original evidence of solvency. And then the thing that makes counsel's blood run cold, to counsel or to be brought to the hearing by whoever is representing you, the original of the charge. Now, I hate this, and I have a specific drawer of my desk that documents like this go into, because I have fear of the original charge. There's only one copy of this and I lose it. I haven't ever lost it, but I'm very paranoid about that happening. So it has to be the original. And again, the judge will do their finger signature test to check that it's all been written on in original format. Your brief to counsel, if you're instructing counsel, just some matters to be aware of. It will be heard in a bulk list in central London, so it's similar to the winding up list in that way. This is really important, and I'll come back to this. Put in your brief that counsel has express authority to amend. This happens every single one of these lists I've ever attended. There will be a mistake, and it's a bit like the asking the court to waive a defect in a winding up petition. If the court thinks it's something really minor, for instance, you've referred to the wrong section of the Companies Act because you've used the HMCTS own forms, then you have permission. If the solicitor has given counsel permission to amend, counsel can just go up, cross out the bit that says 873 and write 859F. So that's a really important thing, and will often get you your order then rather than waiting.
The district judge will have a red pen on her
Yes.
desk, and that's given to you. If you have express authority to amend, you'll be able to go up and make the relevant changes to get this application through. And
I have had whole lists adjourned in the past because the red pen has disappeared, and the judge goes off and searches for the red pen, asks the room if anyone has a red pen. As you can tell, it's a torturous process, but there you go, that's another point to flag. The original charge usually goes with your brief to counsel, so make sure that's got enough time to get to counsel before the hearing. And just to, as an aid memoir for yourself, confirm to counsel that you've sent the original evidence of solvency, and give counsel a copy, although that won't be good enough if you haven't sent it. And then here we come to the crucial bit. So there are 13 in my list, appropriately, pitfalls, referring to the wrong section of the Companies Act, using the HMCTS own forms, misspelling or misstating the company's name happens more often than you would think, and it's connected to this one, which is LTD and limited, which in these matters are the absolute bane of my life, because they're always wrong on something. So just go to the Companies House website, double check and triple check that it's the right name. Issuing in the High Court rather than in the County Court, again, not explaining how the mistake happened. I mean, this is just really a checklist as to the ways in which the matter can go wrong, and we've covered most of these. Yes, sending counsel the wrong charge. You might think that could not happen. It really happens all the time. And I had a completely farcical one in that most recent list where I had 3 matters in the list for the same solicitors. And because I think there were 3 different matters, the wrong charges were in with the wrong instructions. The judge had different ones in their copy charges to their witness statements. So again, you need to be methodical. You need to be really thorough. The last one, not registering the charge in time, again, has happened also to me on multiple occasions, where I have received instructions to attend a case in this list and thought, I recognise that company name. I'm sure I've done this one already. Yeah, I had done it already, got the order, and then they didn't register it within the 21 days again. So that's something to have in mind. And then how to avoid them. I'll go through this quickly. Refer to the right section, give counsel express authority to amend, double checking the name, and double checking that the charge has the correct name on it. Now, this again has happened where the charge, usually it's the LTD limited issue. If you need to make corrections to the charge, make sure you also have in a witness statement why you've done that, how you've done it, on whose authority, and so on and so forth. I've had it before where the charge, for instance, had various details in black pen and then the date was in blue pen. And the judge wanted a witness statement to explain why the date was in a different colour pen on the charge to the other details. So just something to check. And again, as I've said before, because as you can tell, this is a real bugbear, the LTD limited thing, it really does happen all the time. Double check every single document that you're filing in this matter to make sure that you haven't inadvertently included any mistaken ones. Original evidence of solvency, harping on, but it's not entirely clear from the description what original evidence of solvency means, but it's the one that the director or the officer of the company has signed. Again, make sure counsel gets the charge well in advance. I've had them arrive on the morning of, and that's not always guaranteed, so make sure that's there in time, and make sure it's the correct charge. Don't send the wrong company charge. And then finally, act promptly upon receipt of the order once you've got it. As I say, I have had it before where, again, for the same reasons, mistakes happen and they haven't been registered again a second time. And then you have to go through the process again, and you've done really well to get your order in the first place, and it's very frustrating to have to do it another time. So you've only got 21 days from the date of the hearing, and you need to make sure, so get everything in order. Even if you haven't got the order through from the court, counsel will do it the same day, will send it to the court, but the court might take 3 or 4 days to get it out to you. Make sure you've got everything else ready to go to send to Companies House before you've got your order, and then as soon as you've got your order, you can stick it in the post and you're done. Update on the practice of the courts with regard to these matters. As I say, these various things got adjourned the last time I did this list, and the district judge adjourned them to a telephone hearing. That's changed. The protocol is there, the link to it. The relevant section, the relevant parts of it are as follows. They will still stay listed, but it will be done on paper. So essentially everything I've just said is not really true at the moment, because you don't have to attend, you don't have to produce the original charge, and you can email evidence of solvency. So all the things that they insist on in the normal course of things, you don't have to do at the moment. So ignore everything I've said for now, but hopefully this is useful for the longer term. And that's that.
Just very quickly, one point.
Yeah, of course.
And just if you do get one of these applications adjourned, and it comes back, it's coming back again, and it comes, in 3 months or so. Remember the 14 days of solvency. It has to go in again. You can't obviously rely on a previous one. And I've had ones where because it's been adjourned so many times. Within the papers, there's about 5 different statements showing evidence of solvency. So you need to make sure that you've got that updated version within the required time.
Yes.
And I think then we'll let everyone go off and enjoy their Friday.
Yeah. No, the sun's not out. Yeah, thank you so much everyone for joining us in our, well, for me in my living room. I'm not sure where Emma is.
Oh, yeah, sort of the same.
Usually we would love to have a glass of wine and a chat and some wasabi peas afterwards. And I'm sorry that we can't do that for now. I hope it's been useful, and we'll very much look forward to seeing you again when this is all over. Right. Thanks, everyone. I think we will end the broadcast. Thank you, everyone. Take care.